Greetings, family. This is Davon Love, Director of Public Policy, Leaders of a Beautiful Struggle. This is our Legislative Black Agenda Day. Normally, what we've done over the past several years is that we have an event somewhere in the community where we bring people together to preview the work that's going to happen in the upcoming Maryland General Assembly. For those who may not be familiar, in Maryland, the Maryland General Assembly lasts 90 days. This is the period of time where all of the policies, the legislation that is done that governs the state of Maryland, that happens during this 90-day period from January to April. So again, normally, either in late November or early December, we convene folks to talk about what people should be paying attention to, specifically as it relates to issues that impact Black people. There's a lot of things that are happening, both, with the organization. And so we want to spend really the rest of this year really building up our infrastructure so that we can come out full force in 2025. So instead of convening, at a major event as we've done many years in the past, what we've done and we've decided to do is do a special kind of podcast version of Black Legislative Agenda Day, where we talk about our legislative agenda and we invite other organizations who typically would participate in Black Legislative Agenda Day to submit videos that outline their legislative agenda, underscoring the fact that the focus of this event in the past has been focused on things particularly that impact Black people in Maryland. So just wanted to intro that this is the format that we're going to do for 2024. And again, we'll likely return to our previous format in 2025. And so what I'm going to do is I'm going to describe LBS's legislative agenda for the 2025 Maryland General Assembly. Before I do that, though, I do want to just give some general context, because I think when we think about the combination of the fact that, one of the things that many folks are familiar with in terms of those who followed LBS over the past couple of years is, in essence, our battle against Sinclair Broadcasting, right? Fox 45 and David Smith, who was the executive chairman of Sinclair Broadcasting, who also was one of the principal owners of the Baltimore Sun. And I want to give this larger context because many of the issues that we are dealing with, that Leaders of a Beautiful Struggle is dealing with, is impacted by the activities of David Smith, Sinclair Broadcasting, and the Baltimore Sun. And one of the things that, we worked on this past year that I'm sure many of you are familiar with is that David Smith put, I believe, about $400,000 into an effort to put a question on the ballot, on the general election ballot in 2024 for Baltimore City that would have reduced the size of the Baltimore City Council. And this was an effort that is really in line with other efforts that David Smith admittedly has been engaged in, right? He did, something similar with term limits in 2022 and has said that, he will use the ballot question process, use his money to be able to get signatures to put things on the ballot, to have influence over the politics, both in Baltimore and in some ways around the state of Maryland. So, as this is being recorded, the question H, which was a question that would have reduced the size of the city council, failed. And I think that victory is something that is important beyond just the individual issue. I think it would have been extremely problematic had question H passed, because question H would have allowed for David Smith, him being a wealthy billionaire, would have allowed him more easily to buy off people in elected office to execute his agenda, and would have diminished Black political representation, would have opened the gates for more overrepresentation of a white corporate right-wing interest in local city government. So outside of that issue in and of itself, I think it's an important larger issue, because the fact that this was only the second ballot question, usually when people go to the polls, they just vote yes. It's a lot of information, right? And there isn't a lot of readily available information about the questions that are on the ballot. So traditionally, people just vote yes. And this is only the second ballot question of about, I believe, almost 200 ballot questions that have been on the ballot in the past 25 years. It is only the second ballot question that was defeated in that span of time. And so that's a very important, momentous victory. Again, outside of this, just a specific issue, you had a wide range of forces that came together, combination of, officials within the Democratic Party, the mayor, unions, many progressive organizations, many of the, elected officials, folks with Baltimore for Democracy, Green Party, a wide range of radical forces, liberal forces, progressive forces that came together to defeat this ballot question. And what that does is that it pushes back against David Smith and Sinclair Broadcasting, and the Baltimore Sun, and their right-wing political agenda. It's a political show of force against, in many ways, David Smith's ability to be able to use his money to exercise such power, in Maryland and Baltimore politics. So that's an important preface to the conversation about our current legislative agenda. For those who have been following our work, one of the areas that LBS has been engaged in for many years is criminal and juvenile justice. And when you watch or the coverage of Fox 45 or read much of the reporting in Baltimore Sun, what is reflected is an agenda that essentially, what underlies this agenda is a resurgence of the kind of tough on crime, mass incarceration policies, right? And that the resurgence of, mandatory minimums, the preference of detention over alternatives to incarceration, that the resurgence of that policy position underlies much of the coverage and really editorializing of the platforms that David Smith owns and controls. And so much of the political work that will be necessary to move our agenda inherently requires a conversation about the propaganda that is on the other side of us, the propaganda that is making it difficult to move many of the policies that I'm going to describe in a few moments. So while, again, there's a important media criticism of David Smith, Fox 45, Baltimore Sun, there's an even more pernicious dynamic, which is that in many ways, David Smith is collaborating with elements within law enforcement, prosecutors, fraternal order of police, many ways as a spokesperson for the political agenda that would have wanted to continue to implement mandatory minimums, that want to emphasize detention over alternatives to incarceration. And so that's something that is in many ways an essential element of even discussing much of our legislative agenda. One thing I'll add, again, by way of preface, before getting specifically into our legislative agenda, is one of the other aspects of Sinclair Broadcasting's coverage that is important and that impacts our legislative agenda is their coverage of our work on reparations. So for many of those who followed us for many years, one of the efforts that we have been leading on and continue to work on is reparations for the war on drugs. So when the legislature decided in 2022 that it would pursue legalization of recreational cannabis, we were clear that we wanted to ensure that a substantial amount of resources went back into the communities impacted by the war on drugs, and that the compensation or investment in communities impacted by the war on drugs were not reliant on participation in the industry. So we focus on the tax revenues. And so we were able to work to establish a community repair reinvestment fund on the state level. That fund, 35% of the revenues from recreational cannabis goes into that fund. Each jurisdiction gets a percentage of those funds. Those funds then for each jurisdiction, and that formula is determined by each jurisdiction's contribution to statewide cannabis possession charges from 2022 to 2023, with the logic being that those jurisdictions hit the hardest with the largest percentage of the resources. And then each jurisdiction had to pass a law that determines how they spend their portion of the resources. So instead of just giving it over to the executive, requiring that the local county or city councils establish a law that determines how those resources are spent, that then provides the maximum opportunity within the existing government structure we have for the community to have a role in how those resources are distributed. And so Baltimore established the Baltimore Reinvestment and Reparations Commission, where each council person will get to nominate someone to serve on that commission, and that commission will determine where those resources go. There are other places where we write more in depth about both the commission, the nature of the appointees in terms of the criteria that was put in the legislation and all of that. What I want to spend more time on, one of the things that supplemented that is the putting on the ballot, creating a separate non-lapsing fund so that the monies aren't commingled with the general fund. So this was question G that was also successful. And I have to give credit to outgoing Council President Nick Mosby, who put in, the legislation both for the commission and for question G that establishes this separate non-lapsing fund. Sinclair Broadcasting through Fox 45 actually started putting out information discouraging people from voting for question G. And there were several hit pieces. In fact, I actually want to give some significant time to this, is that there was a reporter named, so-called reporter named Julian Barron, who's written a couple of stories about LBS or issues that LBS worked on, essentially using the kind of same racist trope of Black people getting money from the government must be corrupt, right? And this is a narrative that is often used and weaponized against Black people whenever there are public investments in Black organizations, when it is the reality that Black organizations don't get nearly the enough investment compared to their white counterparts in terms of investment of public dollars. And so, Julian Barron, who really should be an editorial writer, like he's not an actual journalist, and was very juvenile in the way that he even approached writing the stories that he wrote. But those stories demonstrate a trajectory where we expect that as we advance the work on reparations here in Baltimore, and as I'll mention later around the state of Maryland, that I expect the Sinclair Broadcasting will continue to use the kind of racist right-wing propaganda that would demonize attempts at making investments and community-controlled public resources that go back into the hands of Black-led organizations. So that's something that, again, is going to become an inherent part of the work that we are doing and will be inflected in our advocacy of our legislative agenda for the upcoming 2025 Maryland General Assembly. So with that as a preface, I'm going to break LBS's legislative agenda in two parts. So the first part is related to juvenile and criminal justice. So the first is we're going to be working to stop the automatic charging of youth as adults. So just to give some background, whenever a young person is charged with a crime, that there are certain charges, there are about 30 or so charges that if a young person is charged with those crimes, they're automatically put into the adult system. And one of the challenges with that is that when a young person is put into the adult system, there are certain services and supports that are not available to them. In some contexts, they are housed with other adults, right? In some contexts, even though the policy is that they should be out of sight and sound of adults, right? And the majority of young people who are charged as adults are ultimately waved down. The last set of data that I saw on this question said that about 2/3 of young people who are charged as adults ultimately are waved back down to the juvenile system. So even though when a young person is charged as an adult, there's a possibility for them to be waved down. And so what you have is a young person who spends time in the adult system who unnecessarily is in an adult system that that is traumatizing for that young person, that contributes to the kind of criminogenic behavior that produces people who would engage in violence. And one of the things that's important to note is that the impact that it has on the young person and their families is something that's extremely important to have in mind, that there are families and young people from whom they are ripped apart as a result of that young person being sucked into the criminal justice system. And having young people charged as adults, right, is a kind of political brutality against young people. And Black youth are two and a half times more likely to be incarcerated than their white counterparts. So the violence and the danger of being sucked into the system is something that is uniquely weaponized against people of African descent. And so what we are merely advocating for is that that young people, all young people, start in the juvenile system. So they start in the juvenile in DJS with the possibility that if a prosecutor makes the case for that young person to be waived up to the adult court, that a hearing can be held to make that determination. Again, in either circumstance, the young person is being detained. In either circumstance, that young person is taken out of the community in terms of being a danger. It's important to note, though, that and one of the things that it's important to keep in mind is that we're talking about young people that at this stage are merely charged with the crime. I think too often what ends up happening in the way that Sinclair and other media outlets report some of these circumstances is that they report these charges and talk about them as if it is definitive that young person committed that crime. And there'll be some of the more extreme circumstances, the more extreme instances of violence, where one could be fairly certain that that crime was committed. The overwhelming majority, right, of young people that are charged with crimes, that it's way less simple than we have in some of the more extreme circumstances, right? So if a young person gets into a fight, gets into a really bad fight, someone is injured in a way that is serious, and they're charged with attempted murder, automatically charging that person as an adult may not take in consideration the fact that they were in a fight. That person, for them, may feel like they were defending themselves against someone that was attacking them. But the policy that would automatically charge that young person as an adult would make it so that that person has to spend time in the adult system. And so those circumstances are way more common than the handful of examples you get in the media when it comes to young people committing, heinous crimes. And so that's important context and understanding the implications of automatically charging young people as adults and requiring that they start in the juvenile justice system. Because again, these are folks that have merely been charged with a crime, not folks that have been convicted of a crime. And again, what we advocate for still provides the opportunity for a prosecutor to put forward a motion to waive a young person up. And if 2/3, as I mentioned, of young people are waved back down, then that means that we have dozens of young people that are exposed to the adult system that unjustly are being exposed to the adult system. So that's one part. The other piece, so that's criminal juvenile justice. And then to complement that, there's been a lot of conversation about the Child Interrogation Protection Act, which, LBS and many other organizations, ACLU of Maryland, Bridge, Maryland, a variety of other organizations worked on the Child Interrogation Protection Act. And so it passed in 2022. It is something that there continues to be attempts by Sinclair and its allies in the media to characterize it as an impediment to law enforcement being able to do their job. And, we actually wrote something, LBS wrote something and published it when they talked about, there was a sheriff in Harford County that used the shooting at Joppatown as a example of the Child Interrogation Protection Act getting in the way. And so what's important to note is that the ability to remain silent is something that adults have the right to. That if law enforcement has to rely on self-incrimination of a young person to solve a crime, then we have a much bigger problem in terms of competence or lack thereof of law enforcement. Additionally, in the Child Interrogation Protection Act, against what many advocates like myself wanted to be in the bill, there's a public safety exception. This is something that, again, we posted on our website and social media, that there's a public safety exception. So when an officer feels that there's an imminent threat to public safety, it is an exception to that rule. Well, we still are seeing, Sinclair, prosecutors, law enforcement talk about a desire to repeal the Child Interrogation Protection Act. So one of the things that we'll be working on is playing defense, that if legislation is put in to repeal it or alter it in such a way that would impair its ability to protect young people from police abuses and self-incrimination, that is something that we will be working on this session. So those are, in terms of criminal juvenile justice, those will be two of our focuses this coming session. And then the other category of things we'll be working on is reparations. So as I mentioned before, our organization worked on reparations for the war on drugs. And a part of our theory was that if we could pass something in the Maryland General Assembly that clearly had as its underlying perspective repairing harm that was done, and repairing harm, particularly when we think about the war on drugs, where there's now more of a mainstream acceptance of the impact of the war on drugs on people of African descent, even by people who ideologically don't agree with my perspectives or progressives or whatever. There are folks for whom have accepted the impact, the negative impact that the war on drugs had on Black people. So that if we were able to pass something that is aimed at repairing harm that was done, then that opens the door for us to say, well, then we can then do reparations more broadly. That there are other aspects of this society that's structured on racism and white supremacy that we think require certain kinds of repair, investment in resources, and the like, in order to deal with the conditions that we have in our community. And I want to be clear, one of the things that we have written about in a variety of different contexts is that our perspective on reparations is not just about giving out cash, though that's one of the things that's on the table in terms of just direct compensation. But for us, what is essential is the importance of investing in Black people's capacity to practice sovereignty. That people of African descent had highly advanced civilizations before the kind of genocidal interruption of our society as a people, the kind of genocidal dehumanization of people of African descent that begins about 500 to 600 years ago, that dehumanization robbed us of the sovereign nations that we had, that allowed us to organize ourselves from a position of strength and power as it relates to the larger society. So for us, reparations is about investment in the kind of ecosystem of institutions that allows us to be able to meet our own needs. And one of the things, there's a piece that I wrote that was published in the Nonprofit Quarterly a couple of months ago, or actually last month. So as this was being recorded, it'll be last month. So by the time folks hear this, it'll be a couple of months, that talk about the importance of vehicles for community investment, right? So building, whether it's incubators, community development corporations, fiscal agent entities. There are a wide range of institutions that provide back-end infrastructure that would allow because part of the problem that we have is that any monies, particularly public dollars or large sums of monies that are invested in our community, typically are invested in institutions that are controlled by folks outside of our community that we don't have control over. And so there are folks outside of our community that are making decisions about how to invest in our community. We need vehicles for community investment in order for us to be able to have the infrastructure to truly be able to practice sovereignty and freedom. One of the things that happens is that when people tend to talk about investments in Black people, what tends to happen is that folks talk about investment primarily through the lens of human social services. And while those are important, we need to think about what it means to invest in Black people beyond providing services, but again, building infrastructure. So our agenda this coming session on reparations will have, there are three planks to our reparations proposal for the state of Maryland. The first is a tax credit between $500 to $1,000 tax credit. We know that there are folks that feel like cash compensation is something that should be on the table, and that makes sense to us. Giving out cash administratively is difficult, it's cumbersome. In fact, one of the things when you look at what has happened in California with the attempt at establishing a Freedmen's Bureau, which we have a whole lot of issues with that. We've written about our perspective on ADOS and FBA. But when you think about the establishment of an entity that would give out cash, like just the resources and money it takes to build the infrastructure to give out cash is something that we recognize the limitations of that. So we think that instead of giving out cash, giving out the state providing tax credits for Black folks. And I think in the way that we think that it makes sense to word it to avoid the Supreme Court challenge, you can't just say, Black people for taxes, in terms of a tax credit. But what we can say is that those who are descendants of those that attended segregated Black schools would receive this tax credit. So what that does is that it doesn't, because maybe there was a white person or two that attended a segregated Black school, right? Maybe. But it's not exclusive in a way that the Supreme Court could strike it down if it was subject to a lawsuit. So that would be the frame we use. So that's the first plank, $500 to $1,000 tax credit for those descendant of folks who attended segregated Black schools. The second plank is progressive taxation. So Maryland has, in many ways, a regressive tax structure where working class people pay a larger percentage of our income in taxes than those who are wealthy. And so we would want to institute a capital gains tax and a capital gains surcharge. So taxes on capital gains, a change to the income tax, where those above 500,000 would be subject to increased taxes. And in fact, in the basis of these tax proposals come from the Maryland Center for Economic Policy. So they have what I would argue is the most robust explanation of these tax policies, in addition to a millionaire's tax. And then the revenues, the majority of the revenues from these tax policies would go into the existing Community Repair and Reinvestment Fund. So again, remember when we talked about reparations for the war on drugs, and the theory was that if we can establish a framework in terms of distributing resources to the community to repair the harm done by the war on drugs, then we can expand that beyond reparations. So the idea here is that you take revenues from those that are wealthy and that those that are invested in the Community Repair and Reinvestment Fund. So it becomes additional, in addition to the cannabis revenues, it becomes additional investment. And then the third plank of our reparations proposal is the establishment of a task force that would study the ways that private institutions benefited from racist policies in Maryland and recommend forms of redress to the Maryland General Assembly. So, private institutions, Johns Hopkins, some of the other major institutions that benefited from, racist policies, that there should be a state-sanctioned study that then allows for the legislature to then be able to have recommendations on how to address that. So that's the third plank of our legislative agenda for reparations. So that's Leaders of a Beautiful Struggle's legislative agenda for 2025. As many of you know, that's our agenda. We support a wide range of other legislative efforts. So many of the efforts that you're going to hear about that'll come after this particular presentation, you're going to hear a lot of folks talk about policies. So when you see our legislative updates, you'll see us providing updates not just on our legislative agenda, but other agenda items that are being offered by our partners who also submitted videos to provide information to the public about the work that's going to be happening in the Maryland General Assembly that has particular impact on Black people. So again, I'm Davon Love, Director of Public Policy, Leaders of a Beautiful Struggle. This is our 2025 legislative agenda. Hope you all will, respond to action alerts, get involved, engage your legislators. Those are the kind of things that actually impact our ability to move legislation. Really, LBS's power to do what we do emanates from the fact that Black folks and other folks that ally with us support our work and put it in the faces of those who are in positions to make things happen. And so, it's really important that you all, I want to thank people who watch this and watch the rest of the presentations. And it's really important that folks stay engaged.
I'm Nika Namdi, Executive Director, the SOS Fund. The SOS Fund has three focus areas: mutual aid, community education, and policy advocacy. In the mutual aid focus area, we provide direct financial support. In the community education focus area, we teach folks how to identify areas, or how to identify vulnerabilities to home loss and strategies and tactics to avoid it. And finally, in the policy advocacy focus area, we work to change the law to remove those vectors of home loss. In Maryland's upcoming 2025 legislative session, the SOS Fund has three main priorities: extending property tax sale protections to homeowners in the entire state. We also want to work on extending protections to heirs property owners through transfer on death deeds, and then finally pushing forward a vacancy tax exemption. For extending the heirs property protections, one of the challenges we foresee is just a lack of understanding by legislators about the impact of heirs property, or even the presence of heirs property in their particular districts. The SOS Fund work centers on Baltimore City, which is one of the areas in the state that has the highest number of heirs property. However, many of our city legislators don't really understand the scope of the problem and how it impacts their constituents. So I think knowledge is one of the biggest challenges we'll face surrounding that. One of the protections that we are going to be working on in this upcoming session for heirs is called a transfer on death deed. It is a statutory form that does not require a lawyer, that would allow people, property owners, to designate a beneficiary for their property that would allow the property to transfer at their death to their heirs without going through probate. And so one of the challenges that we foresee in getting this bill passed is that there may be some issues with legislators really wanting to make sure that folks have to use a lawyer. But using a lawyer presents a barrier to many families, right, and to many heirs in order to have the properties deeded to their name. So again, it goes back to educating the legislators about what is going to be the impact of being able to simply assign a beneficiary designation to your home versus having to find competent legal counsel, and also in many cases pay for it. In terms of the vacancy tax exemption, just to give a little context, in last legislative session, Baltimore City delegation had a vacancy tax passed, and this legislation basically will allow the city to pass, has allowed the city to pass legislation that if a property has a vacant building notice, that its tax rate can be 3 to 4 times the current tax rate. The challenge is there are no exemptions for nonprofit developers who are acquiring properties to rehab them and bring them back into productive use. There is no exemption for heirs who are trying to renovate properties and bring them back into productive use. There's also no protection or exemption for folks who have bought a property from, let's say, a flipper who failed to clear or abate the vacant building notice. And then finally, if a homeowner is unable to fix a broken window or a broken door, they don't have the money to do that, it is likely that they also will not have the money to pay a tax rate that is 3 to 4 times higher than the current rate. And so we are really going to be going back and pushing for these exemptions. The challenge there is there may not be political will to actually protect the classes of folks or that I just spoke about. And so we're really going to have to do some organizing among the legislators to let them understand what is going to happen when you roll out this differential rate and you do not protect the most vulnerable classes of developers, but also more importantly, the most vulnerable class of homeowner. So, in terms of challenges to providing tax sale protection policy in the upcoming legislative session, we just really foresee that the tax lien purchasers and also some of the city agencies, particularly Department of Public Works, will really be trying to amend this bill. Last year it was House Bill 243, which we were able to stop its passage. We were able to stop it from passing because it had been amended to include to return water bills to tax sale, and we knew that that would be catastrophic for Baltimore City in particular. We think that the lobbyists for the lien purchasers, but also DPW, will try to amend the bill again and bring it back. And so we're really going to be looking for folks to come and lend their voices about their experience with tax sale and their experience trying to navigate some of the city services that are purported to help people protect people from property tax sale. So people can stay engaged and support our work by joining our mailing list, which can be found on our website. That's www.thesosfund.com.
Hi everybody, how are you? My name is Catherine Paul and I'm our Policy Director at CASA. I am so excited to be here. I'm so honored to be here. Thank you, Candace. Thank you, Davon. I appreciate being in space with you all. Thank you to LBS for all the work that you have done, that you will do, you continue to do on behalf of Black people in Maryland. Thank you. I don't want to waste any time, so I want to get right into it. CASA's legislative priorities has changed quite a bit following the election, as you all can probably imagine. Right now, we are focused primarily on one thing, and that is making sure that Trump's deportation plan does not get carried out in the state of Maryland. What I want to do is share with you a couple of quick things, not quick things, actually very difficult things that we are going to be working on this legislative session that we can do at the state level to essentially help us protect people, right? And keep ICE from carrying out their deportation plan. So the first thing I want to talk about is something very straightforward. We do not want ICE in sensitive locations or secure locations, whatever you want to call it. And these are these very protected places that everyone should have a right to be, okay? That is our schools, our courthouses, that is our hospitals, right? Our faith spaces. What we want to do is make sure that ICE is not entering these locations. Now, there is federal policy right now that keeps ICE from going into these spaces, but we're expecting that policy to be done with under the Trump administration. And what we want to do is do everything we can at the local level and the state level to make sure that these places are secure. ICE should not be entering into a hospital. People should not have to decide whether they should go and get life-saving care versus be deported, right? Some of you may have heard of that incident, actually not that long ago, of a father who got picked up outside of his kid's school right here in Baltimore City. Parents who feel like they can't take their kids to school, kids who feel like they can't go to school themselves, right? So this is a really important piece of legislation that we'll be focusing on. It was introduced a couple of times, and we know that it's going to be reintroduced this legislative session. The second thing I want to lift up is data privacy. Data privacy is so incredibly important right now more than ever. And what we have heard from the Trump campaign is that there is a plan to use state and local data to file and deport them. What we want to do is limit the ways that the state and local governments can actually share data with ICE, right? Now, some of you all might remember just a couple of years ago, we worked on a piece of legislation called the Driver Privacy Act. Here in the state of Maryland, if you are undocumented, you can get your driver's license, right? So you can go and get your driver's license. Hundreds of thousands of people went and got their driver's license. And then shortly after, we started seeing ICE raids. We started seeing knocks at the doors because ICE had went in to the MBA database and used that information to find people and deport them. We were able to stop that in the state of Maryland. So no longer, since 2021, can ICE just go onto the MBA database for no reason and use that data to find people and deport them. What we want to do now, this session, is make sure that it's actually not just the MBA database, right, that is protected, but that ICE doesn't have access to any other state agency data, right? That includes our school data. This includes the Labor Department, right? It includes a whole bunch of other spaces where data is collected of people who are undocumented. So data privacy will be extremely, extremely important. The next thing I want to share with you, the sort of third priority, and these are in no particular order because I have to express that these are all of the utmost importance this session. But the third kind of thing I want to share with you is our universal representation legislation. So we can all expect legal representation legislation to be introduced this legislative session. Essentially, right now in immigration court, you do not have a right to a lawyer. So that means that when you go into court, you might not speak the language. You may not know anything about immigration court. You are not a lawyer. You have no background. You are going to be forced to defend yourself, right? It is completely and wholly unfair, and hundreds of thousands of people every year lose their cases because they simply don't have legal defense. We want to change that. We have some money in the budget for legal representation, but what we really, really, really need is a public defender model for Marylanders who are going through immigration court. Very basic, a right to due process. This is going to allow people to have a chance, right? But have a chance at winning their case. Now, this doesn't mean that the system is not still racist and unfair and so on, but this at least gives people a fighting chance at being able to win their case and stay in the United States, right? So legal representation in immigration court will be a big focus. And then the last thing I want to share with you are ending a program called 287G. For those who are not familiar with 287G, 287G is a program that essentially deputizes local police officers to act as ICE agents. We have 3 287G contracts in the state of Maryland. That's in Harford, Cecil, and Frederick County. And we want to end those programs. There is no place or space where police officers should be acting as immigration agents. Now, these programs historically have been misused. Some of the worst civil rights abuses have happened through this program, and we need to shut it down immediately. This is part of our pledge, right, as Marylanders, to say we are not taking part in this plan. We are not taking part in assisting the federal government in getting this done. So, 287G, we're going to be focused on transfers and notifications as a whole, right? Why are we helping ICE carry out their plan, knowing their tactics and knowing the way that they disproportionately target specifically Black and Brown immigrants? So those four things are really what I wanted to share with you all today. Again, legal representation, ending the 287G program. We want to focus on data privacy and, of course, keeping ICE out of these really sensitive locations. There's a lot more that we'll be working on around housing and climate and other issues that we have worked on together in the past. A lot of people think, and I just want to close with this, a lot of people think that immigration is not a Black issue. And there's been so much focus at the border, right? At CASA, we are predominantly a Latino organization. But what I want to share with you is that we have a growing Black membership. We have a big group of Cameroonians, Haitians, the list goes on and on. Guys, Haiti is under attack right now, right? We are expecting a big group of Black people, Black immigrants, especially, to be under attack, right? Not only do they face higher higher likelihood, right? And are they impacted disproportionately when it comes to stops and arrests, right, on the street, but also when it comes to deportation, right? When it comes to the immigration system, they're more likely to have harsher results in immigration court as well, right? So Black people in particular, right? Whether you're from Trinidad and Tobago and Guyana, like my family, right? Or from all throughout the continent, the risks are higher for our people in particular. So I'm grateful to be here again. I'm grateful to LBS. I'm excited to coordinate with you all on all of these extremely important immigration topics that are happening this legislative session, and many, many more, many more pieces of legislation that we have to get to the finish line. So thank you all. I'm grateful to you all, and let's get to work. Thank you guys. Take care.
Anna Emanuel, and I'm the Public Policy Director for the ACLU of Maryland. The ACLU of Maryland exists to empower Marylanders to exercise their rights so that the law values and uplifts their humanity. We advocate on a broad range of civil rights and civil liberties issues. However, the issue areas that we primarily focus on are government accountability, education, legal justice, and immigrant rights. This legislative session will be advocating on a number of issues, including removing the governor from the medical parole process. In 2021, the General Assembly removed the governor from Maryland's parole process, eliminating the ability for governors to overturn parole decisions for Marylanders serving life sentences. However, even though it was clearly the legislature's intent to establish that the Maryland Parole Commission be the final decision maker for all parole decisions, the section of the code pertaining to medical parole was mistakenly omitted from the bill draft, resulting in a situation where only medical parole decisions require gubernatorial action. As a result of this error, medical parole decisions made by the Maryland Parole Commission remain subject to a waiting period of 6 months, which is dangerous and unfair for Marylanders who need medical parole. This upcoming legislative session will continue to work with legislators to support a technical fix bill that will remedy this error. Another issue that we'll be working on this session is to pass the Maryland Second Look Act. Maryland incarcerates the highest percentage of Black people in the entire country, at 72% of our prison population, which is more than twice the national average. Shamefully, Maryland also leads the nation in sentencing young Black men to the longest prison terms, at a rate of 25% higher than the next nearest state, which is Mississippi. These facts underscore a pressing and deeply troubling racial justice issue within Maryland's criminal justice system. The only way to reduce existing racial disparities is to create more meaningful avenues for release for those who have demonstrated their rehabilitation. To build towards restorative justice and reduce mass incarceration, the ACLU of Maryland and the Maryland Second Look Coalition will work to pass the Maryland Second Look Act. This bill seeks to address the state's extreme race disparities and advance public safety by allowing people serving extreme sentences who have served at least 2 decades the opportunity to petition the court to reduce or modify their sentence based on their demonstrated rehabilitation. This evidence-based initiative recognizes the transformative potential of focusing on rehabilitation and the urgency of addressing racial justice in our criminal legal system. Another issue that we'll be working on this session is to ensure that police accountability boards have independent investigatory powers. In 2021, we worked to repeal the Law Enforcement Officers' Bill of Rights and passed the Maryland Police Accountability Act of 2021, which required all counties and Baltimore City to establish a police accountability board and administrative charging committee. The purpose of these boards was to ensure that the police weren't policing themselves. However, despite strong community support, research, and best practices showing that independent investigatory powers are critical to community oversight, no PABs in Maryland have this authority now. So currently, PABs and ACCs are relying solely on internal affairs investigations when conducting reviews and deciding whether or not to charge an officer. This session, we will continue to work alongside the Maryland Coalition for Justice and Police Accountability to pass legislation to clarify that local jurisdictions have the authority to grant their police accountability boards the power to conduct such investigations and fulfill their promise to provide community oversight. Another issue that we'll be working on this session is to pass the Maryland Voting Rights Act. Although Maryland has made significant strides to improve access to voting over time, many voting rights abuses and discriminatory structures persist. Legal tools and resources to investigate and prosecute them have been unavailable or too costly. This is in part because of judicial decisions over the last 30 years have chipped away at protections under the Federal Voting Rights Act. In 2025, the ACLU will work with allies to introduce the Maryland Voting Rights Act, which will build upon models enacted recently in New York and California. The MDVRA will enable our state to confront evolving barriers to election participation and root out longstanding discriminatory practices. The bill will do this by creating a civil right to action against voter intimidation. It will also provide broader language access for non-English speaking voters. And the bill will also provide resources to local governments considering changes to election structures and rules. And it will also encourage a streamlined and low-cost approach to addressing complaints of voting discrimination. Lastly, we will be working to defend against attacks against the Child Interrogation Protection Act. All the current law does is require that before police can interrogate a child, they must first contact their parent and guardian, and an attorney must be consulted. The purpose of this law is to protect children from being coerced into giving false confessions by ensuring that they receive age and development appropriate explanation of their Miranda rights. Of course, law enforcement and prosecutors have consistently opposed this law and continue to mischaracterize the state of crime by children in Maryland to justify their call for the rollback of the Child Interrogation Protection Act. Of course, law enforcement and prosecutors have consistently opposed this law and continue to mischaracterize the state of crime by children in Maryland to justify their call for the rollback of the Child Interrogation Protection Act. We defeated their efforts last year, and during the 2025 legislative session, we will continue to defend against these attacks and any attempts to repeal or water down the law. For people who are interested in supporting our legislative efforts, they can do so by becoming members of our coalition, by submitting written testimony, meeting with legislators, especially your own representatives, signing action alerts, and making calls to legislators. For those interested in getting involved, they can do so by emailing me at emmanuel@aclu-md.org.
I am Natasha Darty, Maryland State Public Defender, the first person of color to serve in the role. The Maryland Office of the Public Defender is a statewide agency established in 1972 to represent indigent clients in criminal matters in cases where liberty is at stake. Established as a result of the landmark 1963 Supreme Court case Gideon v. Wainwright, which explicitly states that Sixth Amendment requires the state to provide attorneys to indigent individuals in criminal cases, in criminal, juvenile, parental defense, and involuntary commitment proceedings. We are approximately 1,100 employees, of which half are attorneys and the other half are a talented team of admin staff, secretaries, paralegals, and investigators, peer support specialists, and social workers covering 52 offices throughout the state. from the beach to the mountains and everywhere in between. In fact, OPD is the largest criminal defense firm in the state of Maryland. OPD maintains a holistic approach to representation, and we integrate our social workers from the first day that we enter into our cases. Proudly, the OPD Social Work Division serves as a national model for public defense officers across the country. OPD maintains an unyielding commitment to fight against oppressive systems that strip our clients of their dignity. We do so in traditional, creative, and collaborative ways. In fact, in 2023, OPD entered into an historic partnership with the Office of the Attorney General to create the Maryland Equitable Justice Collaborative. And the Leaders of the Beautiful Struggle is a valued and trusted member of MEJC. MEJC was established to create reform that addresses the underlying causes of mass incarceration, reduce the number of Black people, particularly Black men, in Maryland prison and jail population, and to uplift communities. I'd like to highlight a few of our legislative priorities. In the coming session, OPD will advocate for several things, amongst them, 1, obtaining additional resources to meet the challenges head-on and provide quality legal representation. 2, end the automatic charging of children as adults. 3, promote safer traffic stops. And 4, expand medical and geriatric parole. In an era of ever-changing legal landscape and the exponential growth of technology, for example, body cam, facial recognition, and surveillance devices, the reality is that it's becoming extremely difficult to do this work. True public safety requires a robust public defender system that is sufficiently resourced to meet client needs, retain quality staff, and hold other criminal legal system players accountable. We are the protectors, and despite the challenges we face, we do not flinch from this important role. In addition to the budget advocacy, we have other key areas that we are advocating in the 2025 legislative session. Currently, Maryland law mandates that children as young as 16 are automatically charged as an adult for any one of 32 crimes. There are also 4 additional offenses for which prosecutors may charge children as young as 14 as an adult. This means that when a state's attorney charges a child with one of these offenses, the child's case will start in adult court and the child will be incarcerated in adult jail. Automatic charging has resulted in more children charged as adults in Maryland than in almost any other state. Black children make up 31% of Maryland's population, but 81% of children charged as adults. This practice disproportionately harms Black and brown children, especially Black boys who are systemically vilified and treated as grown men. Facts and data have proven that children, victims, and communities are best served when children accused of crimes first start in the juvenile system, where age-appropriate services, treatment, and education are available. A judge, a neutral arbiter, not the state's attorney, is given the ability to decide where the case is heard. Putting the decision with a judge, the neutral arbiter protects children from the terrors of the adult system while infusing them with treatment and support. In the long run, repairing people and healing hurt best serves the community and leads to true public safety. Another important legislative effort sponsored by Senator Sidnor and Delegate Phillips this session is the Safer Traffic Stops for All bill. Traffic stops are one of the most common ways that police interact with people. Data shows that Black people, and more generally people of color, are disproportionately subjected to pretextual traffic stops. For example, in Maryland, traffic stop data indicates that Black drivers are stopped more consistently despite constituting a minority of the state's population. What is more, Black drivers in Maryland are 4 times as likely to be subject to warrantless searches than white drivers. These stops are often generated by offenses that do not immediately pose harm to the public. They are non-safety related traffic stops. These stops contribute to a racial bias in the criminal legal system, damage relationships between the community and the police, and create more adversarial interactions between police and citizens, which increases the danger to both groups. Safer traffic stops will prohibit officers from stopping drivers for a clear list of equipment violations and low-level traffic infractions that do not pose an immediate threat to driver safety. For example, a broken taillight, window tint, expired registration. This limits a Maryland officer's discretion to use and unfortunately misuse a non-safety related traffic stop, and encourages thoughtful traffic stops to address more serious offenses. OPD understands that certain equipment violation and low-level traffic infractions should be enforced. However, we encourage local jurisdictions to explore the use of new and existing technology, such as red light cameras, license plate readers, and toll photos to ensure repair and expired registration notices go out to drivers. This practice has in fact been implemented in other states and not only keeps roadways clear and safer, but it permits officers to focus on traffic stops that truly go to safety. Sure, it comes to no surprise, but the systemic racism Marylanders face daily does not end in the treatment of our children or in traffic stops. Maryland has significant racial disparities in its incarcerated population. These are the ailing, aging, and in need of help. In fact, Maryland former Parole Commissioner Chairman Bloomberg testified that Maryland's current geriatric parole scheme is unworkable. The facilities are overcrowded and understaffed. Our incarcerated population has nearly no program, no treatment, and suffers from insufficient access to health care. This bill expands access to geriatric parole candidates with an emphasis on those who have little likelihood of reoffending. This will protect public safety and reduce costly medical expenses. The second part of the bill, being introduced by House Judiciary Vice Chair Bartlett and Senator Hettleman, is to clarify and improve the medical parole access. This bill clarifies the legal standards for medical parole and brings Maryland in line with national standards for compassionate release. Every year, we see laws proposed to increase carceral responses to public health and community safety concerns. In these instances, our defensive legislative efforts are incredibly important so that we protect community members from what on its face seems well-meaning, but are in fact destructive policies. We also face challenges to reasonable efforts at criminal legal system reform and evidence-based bills that encourage true public safety, such as those I've mentioned. These challenges are rooted in racism, outdated reliance on incarceration, and quite frankly, fear. For example, OPD supported CIPA, Child Interrogation Protection Act, and it has been under attack since its enactment. We must protect CIPA to protect our children. CIPA requires that law enforcement call the OPD maintain youth access to counsel hotline before engaging in a custodial interrogation of a child. The youth access to counsel hotline is staffed by OPD attorneys 24/7 who simply ensure that children understand their constitutional rights. CIPA truly strengthens investigations by helping protect against false confessions for children. Children who are 2 to 3 times more likely to falsely confess than adults. CIPA does not prevent law enforcement from interviewing witnesses, speaking to community members, and interrogating children who have been properly informed of their rights and choose to waive them. We must work together to combat the false narrative blaming CIPA for poor police investigation, when in reality, CIPA is a critical component to preserving the constitutional rights of our children and ensuring trustworthy interrogations. How can people support our legislative efforts? Each of you can support our legislative agenda by coming to Annapolis to testify, attending OPD community events, sending emails, speaking with your elected members of the General Assembly, and following OPD on social media. Add us on Facebook at Maryland OPD, on X and Instagram at Maryland_OPD, Maryland spelled out, or visit our website www.opd.state.md.us.